So good morning, everybody. My name is Acheng Akena. I am the current Executive Director for the International Refugee Rights Initiative based in Kampala, Uganda, and I'm pleased to be chairing the panel this morning. Thank you for joining. I think we shall go ahead and start, and anyone else is going to be joining the conversation. So this morning we have a very esteemed panel of three panelists who will be helping us to understand the judgment of the East African Court of Justice and what it means not just for Burundi but also for the region as a whole. With me I have Lilian Alex Kimaro. Lilian has 9 years experience working with civil society organizations in East Africa. She has a degree in international law and is now the CEO of the East African Civil Society Organizations Forum. Welcome to this conversation, Lilian.
Thank you, Maureen. Thank you.
On this call, we also have Esther Muigayo-Mnaro. Esther is the Program Officer in the Office of the CEO of the Pan-African Lawyers Union. She is also an advocate of the High Court of Kenya and an active litigator, hopefully legislator in the near future. She has a wide experience litigating before national courts as well as the East African Court of Justice and the African Court of Human and People's Rights. So you're most welcome, Esther, to this conversation.
I'm actually the Program Manager, not Officer.
Oh, sorry. I read that wrong. Sorry, Program Manager, Office of the CEO. My apologies. Joseph Vikanda, the coordinator of the Pan-African Human Rights Defenders Network, African Defenders, and it's the network made up of 5 sub-regional networks of human rights defenders, including East and Horn of Africa, Central, West and Southern and North African human rights defenders. And he has been heading African Defenders for more than 10 years after working with the African Commission for Human and People's Rights. Joseph, you are most welcome to this conversation.
Thank you so much, Acheng, and still a pleasure to be here and share with our friends, some perspective on the different issues affecting Burundi.
Thank you so much. So we'll go right into it, Joseph. I wonder if you can just paint for us a picture of why this case was necessary. What was happening in Burundi in terms of human rights and the status of human rights defenders at the time the case was filed.
Thank you so much, Acheng. Before that, I must say, in 2014, African defenders and defenders conducted a research because we saw perceptive sign that already they are or there might be a possibility of repression against civil society organization. There might be an attempt by the president at that time, Nkurunziza, to run for another term in office. As an outcome, you can see that clearly civil society organizations were not allowed specifically to do their activities. The entire 2014, specifically no meeting held, but we as African defenders and defenders organized one of the biggest meetings, specifically because we use the good office of officials from the Minister of Foreign Affairs to have our activity called Claiming Space Tactical Tools for Human Rights Defenders. But then, during that meeting, at a conference in December 2014, we could see clearly sign already of division. And after our research was published, we clearly call it actually, the title is Burundi, a turning point where we highlighted specifically repression on civil society organization, not only repression, intimidation, arrest, and one of the persons who was arrested is here on this call as we are speaking. There are a number of things, have factors that was restricting the operation of civil society organization ahead of it. And just because civil society organization and human rights defenders decided at that time to join and rally and take the opportunity as just citizens to build a movement that will say no to any attempt to violate their constitution, a movement that will call, not only citizens, but the entire community of East Africa that, if it happens in Burundi, it might happen in another country. So we published that report. The report highlighted critical issues. The report highlighted also the use of youth in that process, arming group of people, to destabilize civil society organization. The report highlighted also the intelligence services that was sent to deploy to attack individuals or human rights defenders and their organization. So we all know what happened. And then we as defenders and African defenders decided that we should not remain silent, but we should seek at least a good office with other partners to find out if there is a possibility to seek for redress and remedy on an attempted coup to the constitution of Burundi. And that's why we assembled civil society organization and asked the court, the East African Court of Justice, whether the interpretation of the constitution of Burundi by President Nkurunziza and his political party was fair to the citizens of Burundi. It's in this regard that we approach Palu with the support of other good lawyers in Burundi to file the case. And I can tell you this is the perception we have, and I know maybe in the course of the conversation I will react as well with different angles, specifically on the ruling, but also specific question related to that case.
Thank you so much, Joseph, for that introduction and for giving us a lay of the land about why it was important to legislate and to bring this case before the court. I'll then ask Esther, so then what happened? So we have this context of several violations of human rights at a certain point in time, and then the case gets taken to court. Maybe tell us a bit about the case, what the results, and what that means for the region.
So, Acheng, thank you. We can't even go to the final decision before giving a background of, what led to the current decision that we want to discuss today. Because we started this case first from the first instance division of the court. And when we filed this case, this was back in 2015. The first instance division of the court, which is like, for a national court would be the first court that you go to, decided to dismiss the case and said that they didn't have merit. Then we filed the first appeal. And on appealing for the first time, the appellate division of the court remitted the case back to the first division to be heard on merit. And, the court said that the court had jurisdiction. So you can tell from the onset, clearly, it seems like the first division wanted to run away from having to hear the matter. But then it was remitted back, they still dismissed it, and that is when now we filed what we call our second appeal in the EACJ case. And if you look at the heading of our discussion today, it focuses on how the court ruled on one of the issues that we had raised as a ground for appeal. And if I may, I want to read that issue as how it was framed so that we have a good understanding of the background of the case. And the issue was whether the first, in finding that the impugned decision of the Constitutional Court of Burundi was not in violation of several articles of the East African Community. So if you go back, you would know that this particular decision that we were challenging is the one that actually said that it was okay for the late Nkurunziza to run for that term. Our arguments were basically pegged on what the Constitution of Burundi provides for and on the Arusha Accord. I know those who are from Burundi would understand more about the Arusha Accord and why it was important for this particular case, because it is in the drafting of the Arusha Accord that the issue of how many terms the president should run for was raised. And because the Arusha Accord had already been domesticated as part of the Burundi law, then the legislators ought not to have run from it, but they should have interpreted it in a way that it gives life also to the Constitution. But the argument of the government of Burundi, the respondents basically, was that Article 96 of the Burundi Constitution provided that the President of the Republic shall be elected by direct universal suffrage for a term of 5 years, renewable once. And then Article 302 of the Constitution provided that exceptionally the first president for the post-transition period shall be elected, and then in quotes, National Assembly and sitting in Congress with a majority of 2/3 of the members. If this majority is not obtained, the first to ballot, it is immediately proceed with other ballots. And then the president elected for the first post-transition period may not dissolve the parliament. Their argument was that these two were contradicting and that they were ambiguous. And it was the Constitutional Court of Burundi's view that the expression exceptionally that is used in 302 is ambiguous on the actual intention of the framers of the Constitution, which was saying that, look, by the time the president was elected the first time, it was not through the ballot. But at the same time, the president had already served a full term, so it is considered a term. And just because then after that is when there were elections, it would mean that would be his second time. And if he ran again, that would be the third time. And our argument was that there was no ambiguity whatsoever. And in case there was any ambiguity, remember the Arusha Accord. The Arusha Accord had aimed at ensuring that Burundi did not go back to the dark days. So actually, I don't know the last thing that people had, so that I can speak from there, because I just dropped out. So I think I was talking about the fact that it would seem that the Constitutional Court of Burundi, while still agreeing that the Arusha Peace and Reconciliation Agreement for Burundi was supposed to be part of the Constitution, only wanted to adapt it in part, and only in the part that would support it, but not in full. Whereas it was very important, because the whole reason that the Arusha Peace and Reconciliation Agreement for Burundi, which we call the Arusha Accord, was made was so that there could be a stop in terms of the conflict that had rocked Burundi in the 1990s, the lack of constitutionalism, lack of democracy. And so it was important that when a court is interpreting whether a decision is constitutional or not, that then they ought to do it, bearing in mind what the Arusha Accord was saying on an issue, and what was the intention of the Arusha Accord, and the fact that it was already a law that they had accepted, that then it would form the basis of their decision. And this was not the case in how the Constitutional Court of Burundi interpreted the issue of the president running for a third term. And it is on that basis that Appellate Division actually did find out that the decision of the Constitutional Court of Burundi was not constitutional, and it also violated several articles of the East African Treaty. Unfortunately, this judgment came a bit too late. The president had already run for the entire third term. He had even died by the time this decision came out. But all the same, I don't think it was in vain, because it spoke about something, and the fact that even the other presidents that come after Nkurunziza already know what this regional court thinks about a president running for more than 2 terms. Actually, I think I'll stop there before I drop off again.
Thank you so much, Esther, for that overview of the case and what was decided and why it is important. So then I will go to Lillian, and I'll ask Lillian about, because we know that cases by themselves are not sufficient. There needs to be civil society support, or at least a civil society congregation supporting any particular case. So, Lillian, could you tell us what role EACJ has played in this case, in supporting the case, and what you think happens next now that we have the judgment?
My name is Lillian Alex. I work with the East Africa Civil Society Organizations Forum. Currently as program coordinator and also the acting CEO, not fully CEO, Maureen. The board is to determine that. Yes, and I'm glad to be here in this space and to discuss more in details about the realities actually with Burundi. So I remember back in 2016 when I was just joining EACJ, that is when I actually found this case already being instituted in the court, as Esther already explained about the first instance division. I remember by then that is when we used to go to court to listen and to try and hear decisions that are going to be made by the court. Now, from my take as a civil society, I think this was very important for us, and we saw that this was the opportunity to actually see how best we can use the avenues that we have at the East African level to solve the grievances that are brought forth by the citizen, civil society. So for us, this was very keen. And I remember going to those court sessions, listening to every judgment, listening to how the case has been thrown back and forth. And at some point, I'll have to be honest, at some point we almost completely lost hope. As civil society, we felt that our efforts are not being recognized. Now, on the ground, as for EACJ, just to give a brief overview of the activities or extent the issues that transpired then. Before even 2017, when I just came in, actually I found a petition that EACJ had submitted with the EAC that was in one of the many issues that were being discussed in that petition was one to suspend or I can say withhold the selection of the incoming Secretary General of the East African Community then, who was supposed, now according to the rotation, was supposed to be coming in from Burundi. So one of the issues they had raised was like just to have him not come into office first so that the situation in Burundi is actually solved. And then again, that didn't go through because we had the Secretary General who just came in 2015. So by the time I was coming in, he was already in office, Mr. Mfumukeko. Liberati Mfumukeko, that was his name. So that was the previous Secretary General. So I remember in 2017, one of the things that really, I could say, IACSOF really stood up to the situation, or stood up to try and raise the voice further on the situation in Burundi, was when the Secretary General's Forum was to take place in Burundi. That was according to the schedule, or I could say according to the East African Community timetable. Had opted that 2017 Secretary General's Forum will happen in Burundi, and as a IACSOF, we stood up against that and released a very strong statement. And we said that the Secretary General's Forum would not happen in Burundi, considering the current situation with the civil society environment in Burundi, taking into account the civil societies who are in exile, taking into account the violation of human rights that have happened, taking into account the failure, or I can say there was no proper reconciliation method that was being put in place. And whenever we tried to, whenever there was a peacekeeping mission, or whenever there was a meeting to actually try and reconcile the situation, we were not getting enough outputs out of that. And so we saw that there was need as civil society to also find our own avenues on how we're going to raise the voice to the situation. And it was then that IACSOF went out and released a statement and specifically said that if the Secretary General's Forum goes ahead and happens in Burundi, then as IACSOF, or generally as the civil society cluster, will not be part and parcel of that SGS Forum. I remember that itself brought in a lot of attention, and a lot of tension. So those were two things that came up out of that for the civil society, considering the current Secretary General was from Burundi. At some point the EACJ really tried to pursue IACSOF to try and convince us to be part of the forum, despite the fact to go to Burundi to actually, do an advocacy plan. But we told them, us going into Burundi will not be sending out the message that you want civil society to send us. So we thought, to hold back will basically now highlight the picture and highlight the situation that is in Burundi. So that was one of the advocacy move that we really made across the region, and that year IACSOF did not participate in the SGS Forum, which sent out a very, strong message across the region on the civil society standing in regards to the situation in Burundi. But then again, I have to be honest, that was not very swift. As I said, it caused a lot of attention and tension, and so there's a lot of back forth and a lot of, spears being thrown to IACSOF and trying to, the Interior Council sat down, and the Burundi ministry was not very impressed with the IACSOF moves. One, refusing to go to the SGS Forum, continuously instituting cases in the court. And so even him as the Secretary General himself was not very much pleased with all of those moves that IACSOF was making. And so at this point, there's a lot of, back and forth discussion, even got to a point to actually consider stripping of the observer status of IACSOF at the East African Community level. So these are some of the outcomes that came out of the advocacy initiatives that we did. And so I'll just go straight to just articulating to now the aftermath. After the whole hearing of the cases and continuous dismissal and, appeals of this case, at least finally, we were very glad to hear that as of 2022, that the judgment came out finally in favor for the civil society. So for us, I think that was a huge milestone. We were really glad to see that finally the rule of law has been upheld, despite everyone seeing that we were on the wrong, despite everyone seeing that IACSOF was attacking the government of Burundi. But then again, the East African Court of Justice sought to actually set the record straight. And even though by the time you're giving the ruling, the president who was then being accused of the constitutionalism was already dead. That was not necessarily a setback, but rather was a large achievement, because at least we are there. We have set a precedent that it is possible for the civil society to actually institute cases at the East African Court. But rather than being possible, we have also set the precedent that civil society have avenues that can work towards solving the civil society challenges we are facing, considering right now we are really facing a lot of the shrinking civic space across the region. So for EACJ, that was a huge milestone and I can say a huge achievement. And now what next? What we're moving forward to? Actually, I would have loved to also discuss more with the discussion we're having today. On our take, what we see as most is, or as next is to try and see how best we can now come back to the table, probably with the civil society from Burundi, and also come back on table the government, probably of Burundi, to see how best to reinstate most of the civil society activists or practitioners who are in exile, to see how best they can go back, because we recognize as the acts of most of our members from the Burundi chapter are mostly operating in exile, and it has been quite a challenge even to invite them or for them to participate in some of the acts of meeting of late. I think there is need to see that, how we can bring back that conversation and, have a reconciliation mission or discussion on the table, but also leverage on the already existing civil society formation that is within Burundi. As the acts of course, we have also new members who are coming in from Burundi, and we see this is also going to be a very good opportunity for us to see how we can bring them to the table, bring them to the discussion, to see how best they can also, advocate from within Burundi on how to have a better situation with the Burundi civil society, the ones who are in exile, and to actually see how best we can have a conducive environment for civil society. But again, using existing avenues, just wanted to highlight this. I just learned that actually the best situation we're having this meeting this year is that, one, the current heads of the chair of East African Community is Burundi, and then we're seeing that the speaker of the East African Legislative Parliament right now is from Burundi. Same as the East African, the president of the East African Court of Justice is also from Burundi. So I think this year should be the year to mark this milestone, to leverage on these avenues, leverage on these positions that are already existing, to actually see how best we can engage these people and further have this conversation, and to see how best we can have a conducive environment. Considering also, I'm aware that the East Africa Law Society conference is actually going to be taking place in Burundi this year. Again, another very strong avenue for us as civil society to see how best we can raise these voices and discuss these issues while within Burundi, and to also see how the legal practitioners from Burundi can actually assist or can actually be partners into ensuring the civil society environment is better in Burundi. So I think those are some of the things we could say that we could have highlighted on best avenues and best practices that we're moving forward from now, so that we have vibrant civil society engagement from all partners. We understand the civic space is shrinking across the region, but I think it's also keen to see how best we can solve the situation so as to ensure effective and vibrant participation of civil society at the East African community level. So for me, I think I'll just stop at that and probably wait for the discussion across the meeting, and maybe we can answer some of the issues that are going to be raised. Thank you, Rachi.
Lillian, thank you very much for that very robust explanation about not just the role of EACJ, but also the role of civil society more broadly in such decisions. I have just two follow-up questions, and then I'll open up the floor for other people to be able to also ask questions. So my first question is in relation to, just to follow up on your last point, Lillian, around shrinking space, and this goes to both Lillian and Joseph. Given this shrinking space for civil society across the region, given the current context of Burundi, given the status of human rights defenders from the country, what prospects, what I'm trying to ask, what does that mean in terms of follow-up actions or ability to enforce implementation of this decision? Similarly, the question also goes to Esther, just in terms of also the countries of the region have not had a very good record of implementation. Has EACJ developed any mechanisms that can assist in ensuring that this decision then becomes implemented? Maybe we start with Joseph, Lillian, and then Esther.
Thank you so much, Chen. This is a wonderful question, and I think I like both, Lillian and Esther's points, specifically Lillian when she was focusing on the prospect But also, Acheng, I thank you so much for the question that is speaking about the shrinking civic space, the state of implementation. I think Estelle mentioned maybe most of the point over there. But where I want to intervene is allow me to put 2 points. First, as you clearly mentioned, the situation of human rights defenders currently in the country, it's alarming, specifically because you are aware, I think 3 weeks ago, 4 human rights defenders from the country traveling from the airport to Kampala for a meeting were arrested, detained, I think for about, and questioned about, their collaboration with other civil society outside the country, that they are aware of their plans, to overturn the country. But also, the second angle that worries me is the statement of President Evariste Ndayishimiye, who rejected, who painted actually the decision of the court as they call it a conspiracy against Burundi. And that raises a question then would be whether sovereignty sometimes allows human rights violation around the world, in Burundi. What will be the state obligation? And specifically in that, my view is that, usually we all know that states voluntarily reduce their sovereignty, when concluding international treaties and agreements to govern their relationship. And thus, their source in the sovereign will be a will of states to aspire to a better democracy. So what we see here, that this is not the case. And then if a state ratifies a treaty, also firmly declares to perform certain acts without hesitation, and is bound to by the treaty as well. Within the framework of the decision of the East African Court of Justice, the state of Burundi is bound to scrupulously respect its decision because it remains the sole subject of the international legal order. That's my view. And, for a president to come out strongly, and actually what he clearly said is that there are a group of people who connive and to go and tarnish the image of the country at the East African community. It's contrary to domestic law. It's an obstacle, a serious obstacle to the emergence of human rights, just as it's, to me, it's perpetually causes serious violation of human rights in the country. And we can see, there are highlights of enforced disappearance, arbitrary arrest, people fleeing their country are not coming back. We have seen even people thinking that they are going back to the country because the country is safe for them. They have been silent and they cannot operate in the country. So those are elements that we see clearly that the country is not stable. And beyond the question of sovereignty that President Ndayishimiye is speaking about, we know that if the most authoritative voice, that is President Ndayishimiye or the President of the Republic, evokes a decision of the East African Court as a conspiracy against the state of Burundi, clear that there will be no political will to comply with the treaties. And therefore, the decision of the East African Court of Justice has to be, become void for them. But we should not accept and allow them this. And I like the point where Lillian mentioned that there will be sometime this year actually a meeting of the East African Law Society. And that question should be on the agenda of the East African Law Society, highly highlighted, and then should be discussed actually in the country to show that, we are aware as East African community, we are aware as, African citizens of all this. But also, it raises the question of sanction. I don't know, maybe Esther will mention something about it, whether or not there should be a sanction regime in this case, especially when we know that Burundi holds, as clearly Lydian mentioned, holds the rotating presidency of the East African community. They hold, the presidency also of the East African Court of Justice, and the lead, the parliament of the East African community. So the question is, will there be a sanction regime, or the East African has a provision for a serious sanctions for states that do not implement their decision? I think this will bring me to court. A prominent Belgian judge, he's an author and also a scholar, Charles de Vichy, who once said that, neither politics nor law will ensure balance and peace for the world without this moral infrastructure to which an eminent contemporary jurist, in the face of the supreme disappointment of his life, dedicated his last NIT. And I think as civil society organization, we should focus on pressurizing the government. We should use all avenues, as Lydia mentioned, all avenues available to us to ensure that the government of Burundi comes to the table to have a serious conversation with its people, to have also a serious commitment implementing decision or whatever recommendation from the different instruments that they have ratified and subscribed to. I think that's what I can share with you now. Thank you, Chair.
Thank you so much, Joseph. Lillian, please, you can go ahead, and then Esther.
Thank you. Thank you for that elaboration, Mr. Joseph. Now, I'll speak to two things before I answer your question, Maureen. Now, to Mr. Joseph, we also, civil society, have been finding it quite a challenge on the whole situation on the implementation of the court cases from the EACJ. The implementation within the partner states. And I think I also forward the same question to Esther, who is going to be speaking next. I hope she can articulate some of these issues, considering that this is not the first time we've had that case for the civil society practice. We also, at some point, there was a case that was instituted against the Media Act in Tanzania, and the ruling was in favor of, or rather calling the government of Tanzania to take measures to amend the act. Now, that was left in silence, and not too sure, but recently there has been a discussion around amending that act. But then again, how well can we measure this? Implementation of the decisions that are made by this court? Because at the end of the day, the court will feel numb to the people, to the civil society, to be one of the areas to seek avenues for the different grievances civil society or even the citizen of EAC face. So I think I'll forward this to my sister Esther, who's going to speak after me, to actually see how best we can craft that. Now, in response to what you asked me, Maureen, the shrinking civic space is becoming quite a challenge right now in the East Africa region. I have to be honest with you. And the ASOF, I remember we've had a number of, how can I say this, stepping toes. After Burundi, we also stepped toes in some other governments, specifically even in Tanzania, we had challenges during the elections. And then when we just recollecting ourselves, then that is when we had the 54-day registration of the registration of the 54 CSOs in Uganda. So those are some of the things that just at some point we felt, as civil society, we felt like you're suffocating. It feels like it's more of a spreading. People look at, the one president looks at what is happening in one country and implements it in theirs. And so even it brings it to the bigger picture for us as YACSOF, also at the regional level. We've been having challenges as civil society as well. For YACSOF, we began this conversation on the shrink and civic space back in 2021. We did consultations, those were virtual consultations within partner states, to actually just have a point where we have civil society discuss the realities of their context within their countries, and then came up with a report. And the discussion around that was actually coming up to build up on having a civic, that is going to be called a CSO bill, operating environment bill. That bill is going to actually speak to how civil society can be accommodated or can operate conducively across the East Africa region. So yet it's still on discussion. Not yet been instituted as a bill. We still have a draft, but we're yet to begin engaging in the East Africa Legislative Assembly into seeing how best we can actualize the discussion on this bill. But then again, as you've said, this is the challenge again we see with the EAC. Sometimes we also have these policies. We may advocate towards this policy for maybe even 5 years to 10 years. And then again, it goes through, but also the implementation within partner states has been very slow, or rather completely not happening. But again, as civil society, we may not be able to reach out to do much or achieve much of the things that we wish to do, but what matters is in the process of it, we raise awareness. So we need to hold more dialogues to discuss these issues, hold more press conferences, press release, just to speak out there and let the people, the citizens generally, the governments of the community to know that these people are watching and we are aware and we are taking note. part of other issue, part of the same shrinking civic space has also led us to having the CSO summit that we are going to be having this year in May. And so this is also an avenue that we thought that we should bring together the civil society across the region to just come and discuss what is happening with us. A lot has been happening. We've done a lot of research. We have a lot of good reports, but then again, pushing them through or having them go through maybe to the governments or the EAC has become not very effective as we had hoped to have that. So at this point, we decided, okay, let's see how best we can foster this dialogue across the region, bring in as many civil societies to discuss the many dynamics of issues that are happening across the region, and best see how we can come up with recommendations that can, be more activities to be taken up upon that will be more effective. So in my point to answer the civic space, it's still a challenge. It's not, I'm not saying it's something that we can wake up one day and say we are done with it. It's a process. But I think my take is for the civil society, and my strong recommendation is for the civil society, we have to carry on. As you have seen in the Burundi case, justice is not achieved all in one day. It took us from 2015 to institute a case to come and get a judgment in 2021. That cannot be easy to be mentioned, or cannot be something that you can say it's something that you could have waited. It took us almost, 6 years to have that judgment come out. So I think even for the shrinking civic space, we need to carry on the effort. I'm taking much note of what is happening in Uganda, and we're looking at it as that situation where it's an early warning system. We need to, the peace and security experts need to give an early warning system, or put an early warning system in place. But then again, I think as civil society, we owe it to ourselves, owe it to the citizen to carry on the advocacy, carry on the engagement at the best level, the best ways we can. And I believe in one day we are going to be sitting and sharing experiences of some of the achievements we have had in pursuing fighting for the space of the civic citizen and the civic space within the region. So I think let's carry on the engagement. My comment.
Thank you so much, Lillian. Madam Baishoko, I've seen your hand, and Shineze, I also saw your hand, but let me just allow Esther to speak, and then I'll allow the two of you to ask the question.
Thank you, Acheng, and thank you for the question on implementation. This is one of those questions that comes up, I think, every time we speak about the EACJ, and it is unfortunate that the framers of the protocol seem to have not addressed their mind fully on how exactly implementation should be done. And if you look at the protocol, you realize it's only one section, Article 44 of the treaty, which talks about how execution of the judgment should be done. But it's also very vague in that it doesn't give a clear way of what happens when a state is not willing to implement. Remember, most of these judgments are against states. It's the states that also came up with most of the provisions of the protocol. So I think they did it actually intentionally, and it is sad that it would seem from the onset maybe they were willing to create a court, but then a court that was more of a dog that bites, that barks but does not bite. It's also unfortunate that for a lot of the decisions, because of the impact they have and the fact that it's the state that is supposed to do something, other states, even when another state is not implementing, are not willing to call out each other, because this would help. If a state was willing to call out on another state that, hey, there was a decision against you and you're not implementing, it would help, a sort of name and shame. But no one is willing to do that, because today it is Tanzania that gets a decision against it, tomorrow it is Burundi. So none wants to call each other out. Another problem as to why implementation is such a big issue is the fact that the appointment of the judges of the EACJ is very political. We can't run away from that. Even when you file a case and a judgment is given, and you probably want to follow up on implementation, the judges don't seem very eager to listen on an application, for instance, for contempt. We just filed our first application for contempt because we're just trying to find out as PALU what can be done, to these states that are refusing to implement. So we had a very good judgment against Tanzania on a case. And because the government has not implemented, we've gone ahead and filed our first ever contempt application against the government. And it's been thrown around here and there, but we are hoping eventually when it is hard, that then it would have created a jurisprudence of that, oh, you can actually sue a state for contempt and get something out of it. Because beyond that, the only other thing that I would say is that for the CSOs and the other stakeholders to not give up, but we can keep pushing for reforms. Just like eventually the court got to have an appellate division, which was not there initially when the protocol created the court. But then over time, there was the need then to have the appellate division. There's need now to keep pushing and advocating for an amendment to the protocol and to have clear provisions of what happens when there's a decision and a country is not implementing. For instance, there's the sanctions part that Joseph was talking about. You know, there should be something that can actually be done. Although, let me say, this should not dampen our spirit as to why we should continue litigating before the EACJ or even before the African Court, which faces the same problem. The issue of implementation is not unique to regional courts only. Even national courts face the issue of implementation, but then we keep building on the jurisprudence. We keep having good judgments. Regimes change, for instance, and there are regimes that come in, and when you have a good judgment, they will implement. So I would say it's not the same as to when you have a good judgment, it is not the same as when you don't have any judgment at all. People may call it a paper judgment because it's not being implemented at the moment, but then there's always the hope that a change will happen and that decision will become useful. And the fact that we have judgments that are good, we can keep waiving them as our reason as to why we are pushing for a change, for instance, in the protocol for an amendment. We can keep saying, look, we have good judgments. We have a reason as to why we are asking that we find a way of implementing this. I don't know if I have addressed your question, even what Lillian had added, but I would say it's to just keep developing the jurisprudence and to keep pushing for amendments to the protocol that would actually give the powers more courts to follow up on the implementation of their decision. And also, if there was a way that civil societies, we could push for a more transparent way of how we get the judges of the court, and a process that is based purely on merit and not on politics. And I don't want to be very political, but we have some countries, and I'll not name, where the person who was representing the AG eventually becomes the president of the court. They already have formed an opinion. They already have a side. It becomes very hard then to pass a harsh judgment against a state. So there's need to have an independent way of appointment of the judges. And I think this is a conversation that ALS is already having with Palu, and I think with EACSOP as well. So we are trying to do something about it, and I think eventually we will succeed, just one day at a time. Thank you, Achim.
Thank you so much, Esther. Madam Barichako, please, you have the floor.
Thank you very much, Achim, and I greet you again. I think what I wanted to say, most of it has been said, but let me say it again. This judgment, I'm talking about the judgment of the East African Court on Burundi, and I think this was really an achievement. It was an achievement because it also clarified some of the confusion that Burundi government and the political ruling party wanted to bring in, that the crisis that erupted in 2015 was caused by civil society organizations and all those people who went out and demonstrated. And today, when we look at that judgment, it is clear who is responsible of the crisis. And I believe that we should be able to work on this, even if the decision is not compelling. We should be able to work on that to demand accountability. Because that crisis has erupted. There are so many people who are still in exile, example, ourselves, and there are so many things that are still happening in Burundi that started in that period of 2015, which we believe should change. And I want to say that we need to find a way of organizing advocacy, a collective advocacy, to speak on the issue of resolving that crisis that started 2015 based on this judgment. So I think this is really a good opportunity for us that we should use to make things change in Burundi and change for the better. Thank you.
Thank you so much, Madam Barichako. Monsieur Ndaishimeza, yes, please go ahead.
Thank you very much, Acheng. Thank you very much for the organizers of this discussion. What I'm going to say here, I think even the question I had, it is the second question you asked the panelists, and I'm so happy with the answer that they provided. First of all, I would like just to say thank you to the EACJ for the support, to the Burundi civil society in particular, but also to the Burundi as a country at large. Because with the support from EACJ, we were able to sue the government before the East African Court of Justice, and with the ruling that came out from that, it is really very, very encouraging. I think whether the government of Burundi recognizes the ruling or not, it is still a huge milestone for us. It is still a huge milestone for the court itself, but also for the whole community, the East African community, because as who was that the last panelist who took the floor, I think this is a jurisprudence for the whole community, and what happened to Burundi could happen even in other member states of the East African community. It's not my wish, but it can happen. And this ruling is really going to serve as a jurisprudence for everybody. For me, the problem is still how the court enforce or implement the ruling or decisions that was taken by this court. What can be that? What are the advocacy avenues that we can take so that we push back our governments, so that we have really the court with all implementing mechanisms in place, so that those rulings are implemented, fully implemented, because first of all, that of community is a political one. But even though it is a political one, it's not supposed to be there on the interests of rulers, but on the interests of citizens. So as citizens, I think we need to explore ways to push back our respective governments, but also on the community, all those community bodies, the Secretariat General, the EALA, but also the court itself, so that we have those implementing mechanisms in place. Otherwise, we will be having rulings, we will be having judgments, but if they are not implemented, it is a loss for the whole community. That is my comment for now, and thank you for organizing this again. But also, I would like to say that when it is organized for Burundians, as Burundians, we are not many to understand English or to speak English. So I think there should be a translation so that many people can be able to contribute. Thank you very much.
Thank you so much, Mr. Ndaishimeza. You make some very valid points, and I do hope that they are taken into consideration. Vital, please, do take the floor.
Thank you very much, Acheng. And as my colleagues have mentioned, I wanted to first commend the solidarity that has been proven in the community, in the civil society organization community, with regard to Burundian situation, very far from the time when the crisis showed some indicators, and most specifically in several actions and areas where we attempted to engage the region and the international community. We cannot say enough thank you, and even today, this panel, which panelists are all from the East African civil society organizations, shows that the Burundian matter is not a Burundian business, but it is a regional, it is East African matter, and we need to act in solidarity to propose and move ahead in seeking the resolution of the Burundi conflict. Second, I want to ask Esther on a very technical matter about the case. The East African Court of Justice mentioned that the Constitutional Court of Burundi in deciding or in accepting the third term of Pierre Nkurunziza violated the East African Treaty with regard to several provisions, and therefore confirmed that the applicant had reason, and as such, the applicant won the case. But later, the court stated that with regard to some remedies, the case was moot. I want you to elaborate more about the mootness that the court found, and tell us if the government of Burundi or the state of Burundi can hide behind the mootness of the case in saying, yes, the court accepted or confirmed that the third term was illegal, but the third term now is finished and the case is moot since Pierre Nkurunziza is dead and we do not have anything to do. So as you talk about implementation of the case, what should we ask with regard to the judgment or the interpretation of the judgment on the side of the lawyers who prosecuted the case? Thank you very much.
Thank you. Thank you so much, Vital. Is there anyone? I don't see any other hands up, and I don't see any other questions in the chat. And so I will just ask one more question, and then I will ask the panelists if you could please respond to the different questions and comments that have come up, as well as make your concluding remarks. My last question is, how do you take a judgment, because it's a very legal document, and make people really understand what it is saying and why it is important? Like, how do you mobilize people around this judgment, excite people or cause them to also want an implementation of this decision? So how do you mobilize a constituency around this judgment? Because usually legal, as a judgment, it's usually very legal and people may not really understand what the judgment is trying to say and why it is important to their daily bread. Okay, I was going to continue, and then I saw Amel. You disappeared. I think you put your hand down. Amel, did you want to speak?
Thank you, Achen. Thank you for organizing this conference. I have a proposal for action. It is useful to initiate a petition asking the President of the IARA in relation to the application of the judgment, even if he is also Burundian. Thank you.
Okay, thank you so much. So back to our panelists. Maybe we start this time with Esther, and then Lillian, and then Joseph.
Sorry, Acheng. On the issue of mootness, it was based on the orders that we had asked of the court. First, the court could not annul the election. That was one. Two, even if the court was to go back to what we had asked for, even in the reference, and set aside the decision of the Constitutional Court, still it was moot, because this case was based on the third term of President Nkurunziza. And by the time the judgment was delivered, that term had already lapsed. So that is what actually rendered the point moot, because all the orders that we had sought against him, and asking that he be stopped from running for office for the third term, he'd already ran for office by the time he got the judgment. He had served his term and he had even died. So that is why the court actually said that it had rendered that particular order moot. So it's just to say that it had been overtaken by events by the time we got the judgment. But it doesn't mean that the country can run, the respondents who are the government of Burundi can run away from the fact that there is a clear judgment that now says running for office should only be for 2 terms and not 3 terms. So it was only moot as pertains to the late president, but not moot on the fact that it did find out that a term should only be 2 terms and nothing beyond the 2 terms. I hope that has answered the question.
Lillian? Go ahead.
Thank you, Maureen. Okay, I don't think there's any question directed to me, rather than more of recommendations on what can be done. I just wanted to, align to what Vital just spoke of to basically see how best we can leverage on the already existing opportunities or avenues that we have on how best we can raise this discussion, like during the ELS conference, and also engage in the civil society from within Burundi to actually see how best they can have this conversation with the government. I think these are some of the things I already spoke to. So mine is just to just put out there that we need to carry on the effort. Achieving this case is not the only it's not the only effort for now. There's much that also needs to be done. As you see, there are still so many other civil society organizations that are still in exile or operating from exile. I think it's high time to see how best we can also join forces to now have that situation resolved. But then again, as Mr. Joseph had already articulated to, again, how safe are they when return to Burundi, and how is it, how can the government guarantee their safety in the situations, issues like that. So I think there's need to see how best we can have this conversation and how best we can bring out the government of Burundi to actually speak to this matter. Because from my take, I feel like most of the times they are sort of avoiding this conversation or avoiding this, responding to some of these issues that are raised in front of them. So I think we need to just find a way on how best we can go within the avenues or the already existing avenues. And actually right now, as I said, is a very prime time to do that engagement, considering we use this word that Burundi is now leading the EAC because they're in so many high positions. So I think in this 1 year, it's the prime time. I think we can try and see how best we can engage with the government of Burundi, considering that they're on the spotlight, to see how best it can be an example to actually solving the narrative or solving the situation of civic space within the partner states. So I think for me that is it. And yeah, I think I'll hand it over to Joseph to also answer some of the issues that were raised.
Yeah, thank you so much. I think it's a wonderful conversation. And when you were speaking, I was recalling an expression by President Wad. For those who do not know him, he was a wonderful advocate and an opposition leader. He once said that you will never win political battles in a courtroom. You will win it in public opinion. So it means the action of solidarity that we are claiming is important to reinforce it. And I think perhaps it has taken long, and Burundi maybe wasn't anymore in our priority list. And I think as a civil society organization, African civil society organization beyond East Africa, so we should reflect again and strategize for a stronger solidarity for the Burundian civil society organization and human rights defenders. The second thing that I would like to emphasize on is perhaps what next. Of course, we think about implementation. When you go to the decision, it's important, and we are reflecting with some of us here, including Dondea, who is absent, but with other colleagues, that perhaps we need maybe the court, the East African court, to make some clarification on the implementation or of its own decision, giving an interpretation of its decision. What does it mean, in practice, to allow maybe stronger advocacy around it? And another point that I would like to mention is our involvement in the appointment, and that was mentioned already by Esther. I think we do not involve ourselves in the appointment of whether judges, even parliamentarian, in the East African community. As East African community civil society organization, it's not only the appanage of the East African community. Even when you look at the African human rights system, such as the African Commission or the African Court, we do not involve ourselves in vetting members that have been appointed. We understand that the process sometimes is opaque. They send not verbal. By the time you know it, the appointment process is concluded. But I think we should be aware of that. And my last point is, the need of a stronger protection strategy for human rights defenders in exile and also in the country. People, HRDs in the country now fear connecting, even communicating with HRDs outside the country because of reprisals or because of repression or because of being labeled as associated to the people who want to overturn the government, or the people who are sabotaging the government. I think that perception has to end, and we need a comprehensive protection strategy, both for people outside, HRDs outside, and HRDs in the country. And I think I'll conclude here, and I thank you so much.
Thank you so much, Joseph. You make some very concrete points about how the narrative needs to change around human rights defenders. I see, I will, Nabasumba, Emil, you have, I'll give you the last question, and then I'll go back to the panelists for their concluding remarks.
Thank you. Good morning to everyone. I would like just to thank the organizers of this conversation. By the way, I'm journalist at Radio Publique Africaine and the founder of Lomanda. I would like just to comment because my question about the implementation has been answered. When I hear someone say that it will be necessary to wait maybe for the change of regime for the judgment of the court to be implemented, I see how difficult it is for the court in question to do justice to the citizens of our respective countries. I think this is a very big challenge. Thank you. But as I said, someone here, I don't remember who, you are going to continue to push. That's someone says here. Just to thank you once again. Thank you very much.
Thank you so much, Nibasumba. I will go back to the panel for concluding remarks and responses to, or any other comments you may want to make as we tie up this conversation.
Actually, maybe I can start.
So please go ahead.
Maybe I just start with the last speaker. I wish to clarify something. I don't mean that when we get a judgment that the only thing we should do is wait for a regime change. No. My point on that was it is good to have a good judgment because it doesn't run bad. It makes a difference. Whether it's the regime that is there now or the regime that comes after, you still have something that you can use. It's different from when you say, oh, because there's no implementation, then I will not file anything. This was just to keep encouraging people to keep filing. And then, Acheng, just allow me to make my concluding remarks. One, I will start with synergize. I think it's very important for all players, be it CSOs, be it litigants, be it citizens, to just energize on their efforts in calling for reforms, even with the court and when it comes to implementation and when it comes to vetting. And I wish to echo what Joseph is saying. Courtrooms are not the only places that we win this war. This is just one of the strategies. It goes beyond the courtroom. And that is why lawyers cannot win this without civil activists joining them, without journalists being part of it, because there's a judgment, fine. The lawyers have gotten it. How do the people get to know about it? Because it's when the people start calling for action that actually you see many countries going ahead and acting. So there's need to amplify the efforts that is happening in the courtrooms, the challenges that are in the courtrooms, that the people get to understand. Oh, we also have a voice as the people, and then they can start calling their states to account. They can start asking their courts, there's a judgment, what are you doing about it? So it's more of a combined effort of a lot of stakeholders and not just the lawyers. And this is not a war that can be won only in the courtroom. The other thing I would say is keep the spirit. Having people that we work with on these cases. I know it's not easy for people like Vital who are not even in their countries, but they keep on the fighting spirit, and it helps keep the agenda moving, and it helps us attain the goals. So it's to not give up and not to have our spirits dampened just because we have encountered a challenge. Challenges, eventually people get a solution to them. So it's to just keep the fighting spirit on and to keep pushing. So I will end there, Acheng.
Thank you so much, Esther. Very poignant in terms of particularly around synergies. Lillian, go ahead.
Okay, thank you, Acheng. Mine is not going to be very far from what Esther's just said. And my concluding remarks will just be basically the same thing that I will just quote from my sister Esther. We need to keep up the momentum. And as she has also mentioned, it's not easy. Also from the civil society dynamics, it has not been easy. And as the EACJ, we have faced so much challenges right now, considering that now we have also civil society from Burundi who want to also engage with the EACJ and they feel that they are not being represented. Most of the times you go into these ministerial meetings and they keep on referring to EACJ as you are the ones who are representing the civil society from exile. So then again, what I would call upon this is to say the same way Esther said, synergize, try and bring the both groups together to have a conversation, see from eye to eye from the civil society who are within Burundi and the civil society who are in exile. Mine, I would really love that to be an opportunity and an initiative EACJ embarks on moving forward to try and see how best we can have a resolvable or reconcile the situation in Burundi. So mine has just also called upon the civil society to be on point and be on board and ensure and carry on the advocacy. As you have seen, it can be delayed, but nevertheless, it's actually going to be there. What matters, what I used to say is even when we're working on different areas, most of the time civil society initiatives may be clashing with government initiatives. But what matters is that you were there, you said something and you did something to actually ensure that the change is happening rather than sitting back and staying silent. So I think we should consider that and keep up the effort. The acts of I'm just going to call upon more engagements, especially having a table or I can say a sit down between the civil society in exile and the ones from within Burundi, and also moving forward and better to see how best we can use these avenues, already existing avenues, the ELS conference, to see how best we can discuss and carry on this discussion further. So for me, I'll just end here and hopefully we can see how best we can strategize and come up with a proper plan on how we are going now to move forward with the situation, or move forward with how best we can handle the situation in Burundi. So thank you, and I hope to hear more from the partners. Asante.
Thank you so much, Lillian, for those clear possibilities in terms of our way forward. Joseph, you have the last word.
Yeah, thank you, Acheng. And I think I have 2 points just to make. One is resilience. I would just illustrate with 2 examples. I remember at the time I was at the commission and we had one support of Ben Ali. And when the uprising came and Ben Ali was ousted, one of the commissioners from Tunisia, who happened to be my friend as well, came to me and said, you know what? Ben Ali misled us. I said, but how? You were supporting. He said, no, I'm not supporting. Second point, our consistent advocacy on Ethiopia since the establishment of Defenders in Geneva, specifically at the African Commission, and you could see diplomats actually not even addressing us, greetings and everything. They consider the organization as very hostile to them. After when Abiy Ahmed came to power, the same diplomats invited us to come and have a conversation, healthy conversation, because, you know, things were not that way, their hands were tied and everything. So, you know, with time, we'll understand people changing their suit and say, oh, now it's just we are Lent time, so we understand what the Bible says about St. Peter. So, you know, people are going to say, no, we don't even recognize them. And that's why we have to be resilient in what we are doing. The second point I would like to make is an appreciation. Appreciation to Palu specifically, you know, and the team behind, you know, championing this initiative, taking it to the court, you know, with little resources, but able to highlight issues. The third, the second is EACJ, Lillian. So you have been present, you have been active, you met in various forums where, you know, Burundi was actually your heart. And I think how, as Lillian, as yourself and Esther clearly mentioned, how do we consolidate, you know, the gains? How do we ensure that, you know, we move forward based on some lesson learned? And I would like to conclude by thanking my colleagues here who joined the conversation, Burundian human rights defenders, to just say that we are with you, but also to Palu and EACJ, specifically Palu, on every litigation cases that we remain available, committed to support the process from the start to the end, whether resource, whether politically, everything. So we are available to provide our support. I thank you all.
Thank you so much, Joseph. That is such a fantastic note to end on. I would just like to say thank you very much. Thank you first for organizing this conversation and for providing us with a platform for this conversation to happen, this very necessary conversation. Vital, thank you so much for reaching out and for putting this panel together. Of course, my panelists, Esther, thank you for coming to the conversation despite feeling unwell. We really appreciate you taking the time. Lillian, Joseph, thank you for your knowledge and for sharing it here, as well as giving us direction on where we can go from here. And thank you all the participants who have joined, those who have made comments, those who have listened in. We appreciate you for being here, and we look forward to continuing to engage on this very important judgment. I think it is who works with Esther who said that the more we engage our institutions, the better the results we are going to receive from those institutions. And so I'm using this point to encourage us not to let this brilliant judgment just sit on a shelf somewhere and gather dust, but let's use it to mobilize, let's use it to build a constituency, not just for Burundi, but also for the entire East African region. So with that said, thank you very much, everyone, and we look forward to continuing to engage. Maybe I'll ask the panelists if they could leave their contact details in the chat so that people can get back to them in case they have any additional questions or any ideas for engagement. So Lillian, Joseph, Esther, if you could please include your emails in the chat. Other than that, thank you so much, and goodbye. With your emails in the chat. Other than that, thank you so much, and goodbye. With your emails in the chat. Other than that, thank you so much, and goodbye. With your emails in the chat. Other than that, thank you so much, and goodbye. With your emails in the chat.